Welcome once again to Lehto's Law. Here's Steve Lehto.
John sent me a note on a topic I get a lot of questions about, and that is expungements. Expungements. If you get arrested and convicted and then your record is later expunged, who has access to what is still there? And, what happens if people start asking you questions about it? Well, here's an interesting twist to that. From Asbury Park Press, and Olivia Leo wrote this, a legal complaint, that's a lawsuit, to remove an arrest record raises free speech issues. But what's happening here is a guy was arrested, later his records were expunged, and now he wants a newspaper to remove the story about his arrest because he said, hey, it was expunged. And there's going to be a legal fight over this. In an attempt to keep his assault arrest from showing up on internet searches, a resident has filed a criminal complaint against a local news outlet to make them remove the original news item. The lawsuit raises the issue of what the press can print and what restrictions the government may impose on it. The publisher of the newspaper and the reporter were named in the complaint that was filed by the man whose record was expunged. And his record was expunged about 6 months after the arrest. Interestingly, of course, when they published the original story, it was true he had been arrested. But, of course, now a Google search of this man's name brings up articles about his attempts to get his name removed from the monthly police blotter on a very small local news site, the old Streisand effect. So despite the expungement, his name also still appears on the initial news site regarding the hyperlocal news. This case, of course, speaks to the larger issue of free speech and whether the government can dictate what a media outlet can or cannot do, says the attorney for the news outlet. So the attorney argued the expungement only applies to government records and not newspapers or social media posts. He said, you can't edit history. People remember it. If something's true, you can't sue for defamation, which requires something to be false. If it's not false, well, it happened. So this news outlet reached out to the man trying to get his record cleared up and couldn't be reached for comment. The reporter says nobody should be defined by where they started or a rough patch in their life. And at this media outlet, we understand the intense responsibility we have, not because it's legally required, but because it's who we are. We have policies and systems in place to make years-old minor and dismissed arrests invisible to search engines. But the government using the criminal code to force journalists to unpublish lawfully obtained and wholly truthful reporting is not the solution. So back in August of last year, the man at the center of the story was arrested for simple assault. That incident, along with 34 other arrests, were published on the media outlet's website in September. The information came from the local police department's community bulletin, which also published that the man was 40 years old, where he lived. He was arrested on this date in this area for simple assault, and they gave the name of the police officer who made the arrest. Other publications also published the August police blotter. So under every police blotter is a statement that says, an arrest is not a finding of guilt. That's something for a court to decide. We publish this information in continuation of a great American newspaper tradition because we believe it has community value. In March of this year, the municipal court signed an expungement order regarding the man's arrest. The order states that the arrest shall be deemed to have not occurred and an individual may answer accordingly. So if he's ever asked by an employer, have you ever been arrested? He's actually allowed to say no. So the question is, does that apply to job applications or internet websites run by newspapers? So in April, the reporter says that the man at the center of the story was calling him to demand that his name be removed from the website. He declined to remove the man's name, stating that was not required by law. They did update the website, explaining that the arrest had been expunged and saying that that's how we handle this. So in late June, the man filed a municipal complaint stating that because he was falsely arrested, that all charges have been dismissed or expunged. The statute requires them to unpublish it and that the editor and the publisher have refused. Now, there is a statute that says that a person can be fined $200 for revealing the existence of an arrest, conviction, or related legal proceeding with knowledge that the records and information pertaining thereto have been expunged or sealed. But what a lot of people miss when they read a statute is you might go, well, Steve, that makes it illegal. No, it's talking about you revealing something when you know that it's been expunged with knowledge. But if it was posted here, you couldn't have knowledge that it'd be expunged in the future. And they didn't publish it in the future. They published it back here when they found out about it. And so they couldn't have known about the expungement, which hadn't happened yet. And so the attorney here argues that the state statute would not apply because the expungement happened after the article was published. And then he also says it would not apply to articles and social media posts because if it did, that'd be a violation, of course, of the First Amendment. And so it's an interesting argument. And by the way, I completely understand the guy's position. I completely get it. If I was arrested and I thought it was a false arrest, and then later someone agreed, yeah, we'll expunge the arrest records and you're not going to get prosecuted and whatever. And then I'm thinking about it going, but it's still out there. My arrest story is still out there because these different newspapers are publishing it. And I understand the idea that if you publish it here and it stays on the internet, it's actually almost continuously being published in the sense that if somebody goes to look for this today, they'll find it the same way they would have found it a month ago, 2 months ago. And so I can tell you that a lot of people don't notice when articles were published. And so it very well could be that someone could find the article today and assume the guy got arrested yesterday. They don't pay attention to the numbers and dates and so on. But of course, they say, we published the story about the arrest because it was true. And then when it got expunged, we published that too because it was true. And so keep in mind, the thumbnail description is that spoken things about you that are false could be slanderous or slander. And then written or published things about you, okay, I think written would be libel. And both of them are classes of defamation. Defamation, the overall class, requires that something be published about you, spoken or written, that is false and it hurts your reputation or harms you. And I'm summarizing this. But if something is true, you kind of lose your case. And that is a common thing you'll hear people say. Truth is a defense. So if they go to court on this and they had a trial, a judge would look at the plaintiff and say, what is your allegation? The allegation is, they published something about me that hurt me. Okay. Was it true at the time of publication? Yes, it was. Okay. What's your case? Oh, hang on a second. Got something else here. We've got this statute that says that they've published a story, the existence of an arrest, with knowledge that the records and information pertaining thereto have been expunged. Okay, but when did they publish that? Months before the expungement. So they couldn't have had knowledge of the expungement before it happened, could they have? So I have to imagine that this is what we call a non-starter. But we'll see what happens. But John, thanks for sending that. It's a fascinating story. And like I said, I feel for the guy. I really do. But unfortunately, these things happen. So the good news is that as time goes by, more and more stories hit the press. I'm not going to say the guy's name because I don't want to add to his problems. But he's got It's an interesting name because I recognize it because it's Finnish. It's a name from Finland, but as far as Finnish names go, it's a fairly common name. So give it a little time, and I suspect that time would solve this and make it go away in the sense that the story would get buried with all the other stuff that's happened after it. But Olivia Leo wrote this. John sent a thanks a lot from Asbury Park Press. A legal complaint, that's a lawsuit, to remove an arrest record raises free speech issue in Red Bank, New Jersey. Questions or comments, put them below those. Talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Please deposit 40 cents more for the next 3 minutes.